Good evening, everyone. Please rise and join me in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good evening, everyone. This is the regularly scheduled meeting of the Board of Estimate and Taxation for January 2011. Several non-routine and then a couple routine applications that will come before us this evening. The first one is PW9. Call on the Budget Committee Chairman, Mike Mason.
PW9 is a release of conditions for $750,000. I'm sorry, thank you. To our capital project B345 59560111131, and I move it on behalf of the Budget Committee.
It's been moved and second. Discussion.
Mr. Chairman, PW9 is a release of conditions for Central Firehouse to cover the following expenses. Holly Hill rent, where we have left the Fire Department administration, so it'll cover another year's rent. Construction management company with URS for design phase. A&E funds to develop architectural renderings, true numbers, and cost to a point where we apply for municipal improvement and are requested to approve funding for construction. This release does not cover the following: demolition, site preparation, and construction costs, design, relocation costs for the career force, 2 volunteer companies, and fire apparatus. Does not address a plan to It does not have a plan to address GEM's administration and training needs. And if I may continue on. Since the RTM decided to reduce this capital project to $750,000 until more information and some of the similar concern our board had, a tremendous amount of work has been done. This doesn't mean that we are where we might want to be. The Budget Committee has addressed many concerns, and here is a status report. GEMS doesn't need to have space that meets the 2004 building requirements for emergency responders. Basic Class A office space would meet their needs, along with a vehicle and service storage area. Our committee revisited the town agreement with GEMS and noted that the town has a commitment of just over $200,000 a year towards their rent. The town has joined GEMS at the Art Barn and plans to work on a location on King Street. The first selectman has assured us that the operation and consideration of GEMS is still there, however, not in this particular project. Our committee will continue to seek a viable solution for GEMS needs. The current plan is to replace the current structure with a new facility. Many questions and alternative plans have been raised. Our committee feels, although many of the options being discussed today were in fact discussed and reviewed at one point or another since 2001, when we originally began the Public Safety Complex project. The current plan may have hurdles to address with our land use agencies. However, the Budget Committee and the town professionals believe that this is the best, most economical route to pursue. The temporary plans to accommodate fire coverage during construction have obviously made headlines. The Budget Committee has noted that further discussion is needed on this subject. Simply put, the request for the funding is just ahead in our budget deliberations in February. We have also not concluded the discussion about King Street Station and the related conversation about staffing, GEMS, and an overall future planning for firefighting moving forward. The first Selectmen's capital budget wasn't available at our meeting, and obviously now has been released. These dialogues will continue in the very near future. So, releasing this condition is the next appropriate step for our town. Our vote was 4 in favor, 0 against.
Further discussion. Mr. Raymer.
Yes, to raise a point here that I had mentioned also at the time of the budget meeting, and I'm raising it again because there were not very many members of the BET who were present at the Budget Committee meeting the other day. Of the $750,000 sum, and that $750,000 sum was a sum that was selected by the RTM in its reduction. It wasn't a sum that was selected by our Public Works or by the BET. Of that $750,000, about $150,000, according to Mr. Minnelli anyway, is a sum which is going to be applied towards the rental for temporary quarters of fire department personnel. And I have some mild misgiving about showing what's really more in the nature of an operating cost as part of a capital item. I'd rather see rental sums in the future shown as being an operating cost. I recognize that when you have these temporary operating costs in conjunction with a construction project, it's kind of a hybrid situation, that it's an operating cost, but it's an operating cost which is a result of the capital project that you're doing. But I'd rather, frankly, personally speaking, be seeing these rental sums shown as part of an operating budget and keep our capital funding restricted to the capital cost of construction without these operating costs. It's not important enough to me to vote against this item, certainly. There's been nothing but too much delay in this project anyway. I offer these remarks only in hopes that perhaps we'll handle it differently in the future.
Further questions? Okay. All those in favor of PW9 signify by saying aye.
Aye.
Opposed? Abstentions? That's that 10-0-0. I believe we have two members who are absent this evening on previously scheduled trips. Okay, 10-0-0. Thank you. The next item to come before us, PW10. I call on our budget chair, Mike Mason.
PW10 is a release of condition for drainage improvements for a sum of $231,000. The project note is depicted, and I so move that on behalf of the Budget Committee.
Moved by Mr. Mason, second by Mr. Simon. Discussion.
If I may, PW10 again is a release of conditions for a capital project. This is a continuation of drainage projects that were appropriated back in the year 2009. This will address three projects in the Pembroke area that were identified back in 2009 when we were beginning to evaluate the materials submitted from the consultants the town hired to begin looking at overall drainage conditions across the whole town. The BET conditioned the appropriation in order to allow the Department of Public Works to lay out a plan, including a timeline for the defined project. This release addresses three projects affecting drainage on the east side of Pembroke Road. The Department of Public Works has chosen to do the engineering work on this project in-house. It does reduce our project cost in the long run, but it obviously changes the timing for the department's ability, rather than if we outsourced it. Discussions are continuing to move forward. We're still limited on how much we can get done on these projects at any given time. These projects will be released, they'll be committed, they'll be completed this year. Our vote was 4 in favor and 0 against.
Further discussion. Once again, just like the previous application, these are release of conditions. This is not money that's coming out of contingency or fund balance. It's money that was budgeted in prior budgets and simply being released as a condition that the BET placed on these appropriations. Discussion? All those in favor signify by saying aye.
Aye.
Opposed? Abstention. 10-0-0. SE 10 now comes before us. I believe the Law Committee, its Chairman Nancy Barton.
SE 10 is the request for approval of $200,000 for a settlement with the Environmental Protection Agency and the Department of Environmental Protection of the State of Connecticut as part of an overall settlement agreement with those two federal and state agencies that will ultimately cost the town more in future years that will come through the CIP process, and I move approval.
It's been moved by Ms. Barton,
Second.
second by Mr. Campbell. Discussion. Ms. Barton and then Mr. Mason.
The background of this settlement is the 2008 failure of a section of the Old Greenwich Common Force Main, which runs from Old Greenwich under the Mianus River through Coscob and ultimately into the Mianus River. It broke in 2008, and you all may recall that it remained unfixed for about 5 days while we awaited approval of the gas company, and there was a discharge of $28 million gallons of sewage following a 2005 failure of the same force main. So the town of Greenwich was subject to some significant demands by the EPA and DEP and was able to negotiate a settlement calling for a $200,000 fine. In addition, there will be replacement of the affected section of the force main, and the remainder of the line will be studied with a view to determining which, if any, additional portions of the main may need to be fixed. If the main breaks in an area that we do not negotiate with the EPA needs to be fixed, there will be further enforcement action and potential further cost, which we should all recognize. But the immediate request is for the $200,000 for the fine.
Mr. Mason.
The Budget Committee also visited that, and we had a very, very detailed presentation on this, and obviously our vote was 4-0 on this as well. But, setting the stage up for the future implications, so we just had some concern on that, but other than that, we were in favor.
Mr. Walker?
Ms. Barton.
I neglected to state that this settlement was approved 2-0 by the Law Committee.
Thank you. Further discussion on this item? So, just to make sure it's clear, this is for $200,000, but it does set up amounts of money to be determined, but arguably some significant amounts of money anytime you're dealing with sewers for the repair and/or the replacement of sections, large, small, to be determined of this force main. And so we're looking at implications to future budgets as a result of this, although at least based on these committee votes, it sounds like this is the best deal. But we should all be cognizant of the fact that this is going to cost us money in the future, money that we're going to have to spend, and money that's going to take away from other projects. My understanding also is that there's a discussion to be determined as to whether this is sewer improvement or sewer maintenance. And so I just want to make sure it's clear that everybody in the room tonight is on the same page, that that issue is yet to be determined and is not being resolved as a result of this vote here tonight. Is that correct, Ms. Siebert? I guess I'm looking. Jean in the back from the Law Department?
I haven't heard anything new since,
Okay.
since last Thursday.
Fair enough. Ms. Barton?
I think what we're being asked to do is to approve the settlement agreement with the EPA and the Department of Environmental Protection of the State of Connecticut, which calls for a $200,000 fine and has additional provisions which, once we agree to it, we will have to comply with, financial and otherwise.
Okay. So, everyone's satisfied with either the discussion that you heard at the Law Committee or the discussion you heard at the Budget Committee. And I suspect that if we're going to go into much greater detail, we would need to go into executive session. Okay. All those in favor of SE 10 signify by saying aye. Aye. Opposed? Abstention. 10-0-0.
Okay.
RF5 now comes before us. I call on Joe Pellegrino from our Retirement Board liaison.
Mr. Chairman, I would like to move on behalf of the Retirement Board, RF5, a request to amend an existing contract between State Street Global Advisors and the town.
Second.
It's been moved by Mr. Pellegrino, second by Mr. Simon. Discussion?
If I may, Mr. Chairman, this amendment would allow the Retirement Board to invest in State Street's EFI index. This is an index that follows 1,021 equity securities in 21 countries, those countries being in Europe, Australia, and the Far East. The Retirement Board plans to terminate its investment with its current active manager and in international investments and move into this index. This would allow the pension plan to capture the index return as well as reduce management fees. The Investment Advisory Committee met on January 6th and approved this amendment 4-0. The funds currently under management in this strategy are approximately $45.5 million.
Ms. Barton?
For the record, the Law Committee approved the documentation as to form at its meeting on December 20th last year.
Further discussion? Approval of the contract, RF5. All those in favor signify by saying aye. Aye. Opposed? Abstention? 10-0-0. RF6 now comes before us. Joe Pellegrino again.
Okay, Mr. Chairman, on behalf of the Retirement Board, I'd like to move RF6, which is a request to enter into a contract with TCW EIG Alternative Investments, LLC.
Moved by Mr. Pellegrino, second by Mr. Simon. Discussion.
Mr. Chairman, the Retirement Board would like to make a $10 million investment in Energy Fund 15. Energy Fund 15 will make asset-based financing in energy projects and companies, energy companies, on a global basis. The asset-based financing will be project financing oriented or mezzanine financing oriented. The fund will target gross returns between 15 and 18%. Investments will be structured such that a current return will come back to the pension plan. The investments by the manager, that's Energy Fund 15, will target projects in Canada, the United States, Western Europe, and Australia, but it may invest up to 25% of the fund outside of these regions. No single project can be more than 15% of the commitment of funds to the investment vehicle. The management fee is 1.25%. There's an 8% preferred return before a performance fee of 20% to the investment manager. The Investment Advisory Committee voted on this 4-0.
Ms. Barton?
The Law Committee approved this investment as to legal form also on December 20th, 2010, by a vote of 2-0.
I would just note in the audience, today's Jim Lavin, our program administrator. I suspect he's here, though, on another matter. We're not going to take that up to under new business just by virtue of the agenda. Some nuances there, so I'd ask that you hold off for a little bit. But I appreciate you being here tonight. Discussion on RF6. All those in favor signify by saying aye. Aye. Opposed? Abstention? 10-0-0. Item 3 now comes before us, consideration of routine applications. I call on our clerk, Joe Pellegrino.
Okay, Mr. Chairman, I'd like to move CD4. This is a request by Community Development to use $68,750,000. It's a repositioning of funds. The use of the funds would be for St. Luke's LifeWorks roof replacement, that being $11,300, and a boiler replacement at Franklin Commons, also under the jurisdiction of St. Luke's, for $57,450. The funds that will be made available come from the repayment of a former CDBG subrecipient. Period.
Moved by Mr. Pellegrino. Second by Mr. Mason. Go ahead to CC2, and then we'll take them both.
Okay. CC2 is a request by the Conservation Commission for additional appropriation of $4,000. This is for public outreach, and it's so that the town, which is automatically eligible, may seek a $4,000 micro grant. And I think I'll stop there. Thank you.
Is there a second?
Second.
Second by Mr. Simon. Discussion on any of these two items? All those in favor signify by saying aye. Aye. Opposed? Abstention? 10-0-0 for the two routine items. Item 4 now comes before us, the assessor's report. Our assessor, Ted Gortney. Also, we have in the audience our assistant assessor, Bob Shipman. Good evening.
Good evening, Mr. Chairman and members of the board. You have my report in front of you. I'll be glad to answer any questions about it.
Discussion or questions for our assessor? Ted, I see in your report, obviously we're going through the informal hearing process. If you could just give a little bit of overview of not just the numbers behind it, but maybe a little bit of a flavor for what's happening, numbers, and maybe any issues that you think are most pertinent to this revaluation and some of the things you're hearing out on the street.
Well, we've had about one-third the number of individuals appear at this year's informal hearings as compared to the 2005. Generally speaking, the comments I've been hearing have been positive about the revaluation. We do run into problems occasionally, and those are being dealt with as a result of the informal hearings where people come in and are able to present some mistake or some judgment that they want to be reconsidered. So we're going to be completing these hearings the end of this month, and we think we're quite satisfied with the results. We have been reviewing all of the results of the hearings and inputting the results, and we'll be sending out notices to all of the individuals who attended a hearing by the middle of the coming month, February.
Okay, can you just run through the deadlines again? Obviously, for anybody who's watching this on Channel 79, it's important for people to understand that the difference between the informal hearing and even if you don't get to the informal hearing, what you need to do to get to the formal hearing, and then the deadlines you take from there.
The last day for the informal hearings will be the 31st of the month of January, and there's still appointments available. If you would call the revaluation company, they'll set a hearing for you. Following that will be the Board of Assessment Appeals. The deadline for filing a Board of Assessment Appeal would be on the 21st of March. They'll be holding their hearings in April. It's important that you file the appeal before the 21st of March, and there's forms available both online and in the assessor's office, or you can attend the Board of Assessment meetings, which will be held here, or the signing up sessions be held here in the town hall the first 21 days of March, and you can just come in and they'll give you an appointment right at that time.
So what happens if, once again, if you can tell the audience, what happens if it's February 1st, you haven't not done an informal hearing? Can you still go to the formal hearing as long as you get that in by March 31st?
March 21st.
Sorry, March 21st.
Yes, you do not have to have an informal hearing to go to the Board of Assessment Appeals. However, to go beyond the Board of Assessment Appeals to a Superior Court case, you do have to have an informal hearing. So it is important that if you still have any concern about your assessment, you file an appeal before the 21st of March.
Mr. Raymer?
I think Ted might have inadvertently misspoken. You said that you cannot take a court case unless you've had an informal hearing. You mean to say you can't take a court case unless you've filed an appeal to the Board of Assessment Appeal?
Thank you for that correction, yes.
Is that the same correction Mr. Finger was going to make? All right. That was just a test to make sure everyone's listening here. So just to be clear and to reiterate, you do not have to go to the informal to get to the formal. Your deadline for the formal, although we would like you to, and the deadline for that is January 31st,
Yes.
is when you're going to stop having the informal. Your deadline is March 21st to file a formal appeal. And in order to then appeal that decision or to take a court case forward, you must first have your formal appeal adjudicated by the Board of Assessment and Appeals.
That's correct.
So I think that's important. And as we are out there in the community as well, making sure that people understand their deadlines and timelines as we move forward with this. Okay. Further questions, Mr. Simon?
My questions deal with the tax relief for the elderly, my favorite topic.
Yes.
So I have two questions. Having read, I wrote you a series of questions, you answered most of them back. And then I asked you, I don't know if you got the email to bring a copy of the ordinance to the meeting. You may not have gotten that email.
No.
But there's two questions I have. One, you wrote back to me that you're basing the credit this year on what you expect the mill rate increase to be. But I don't think the ordinance is based upon what we expect the mill rate increase to be. It had to be based on the prior mill rate increase.
However, the benefit has to be determined by the end of January because we send out all the notices next week.
I got that. That's why I think you should review the ordinance with the law department, and I think you're using the wrong, you can't be using the mill rate that we're going to pass in May. You have to use the mill rate that we passed last May. That's how I would read it, but I think you should get clarification from the law department.
All right, I'll seek that
And
clarification.
the law department clarification person is actually in the back row. So we're in luck here. We can have like an expeditious meeting. The second part is, and you can get clarification from me, you round up the tax credit, although there's no provision in the ordinance to do that. I realize you think the public can only deal with zeros, but I think we should look at that, and I don't think we should round up. I think we should give an exact credit. I think we can round to a dollar amount, but I don't think you should be rounding up to the nearest $10 or down to the nearest $10. That's just, and other people can opine on that topic. And if you do round up and down, I think you need to make sure that you're not taking a percentage increase on a rounded number every year, that you go back to your baseline and then calculate the change. And then if you want to keep rounding that up, that's one thing, but not to take the percentage change on the rounded number.
All right?
But I would like to get that clarified. I don't think you're using the right mill rate, and I'm not sure these are the right credits.
We'll seek immediate advice on that because we want to get the letters out during the next week.
Right, because you wrote you used 2.9% for this flyer,
Yes.
but there's no way of knowing what the mill rate increase is going to be. And it's not supposed to be based upon the mill rate increase that's in the future.
Well, as you point out, Mr. Simon, the law department is in the audience hearing this discussion. I suspect that a response from them will be forthwith, and that issue can be handled. It would appear to be a straightforward question. Will yield a straightforward response. So we'll apply that number. Your next question, though, if I heard you correctly, is not just the mill rate to be applied, but then whether or not there should be a rounding effect to the credit to the nearest $10 as opposed to the nearest dollar. Opinion from the other members of the BET concerning that, I suspect that the way we drafted the ordinance, it's silent as to that.
Correct. It didn't anticipate rounding.
Does the board have I'm not sure we need a formal vote for this, but obviously it's important enough, especially if I think the concern necessarily isn't rounding to the nearest 10, it's rounding to the nearest 10 and then rounding to the nearest 10 again and so forth and so on, and then it becomes out of whack with what the intent was.
So, Mr. Chairman, I think unless the ordinance says to round up or down to the nearest $10, I think if it's silent on that question, I would think we just go to the dollar, the actual dollar amount. I think that'd be the standard interpretation.
Any objection to Mr. Campbell's comments?
No.
Okay, so that'll just, if you can just make that change, I think that would be helpful.
All right.
But then I can suggest that you go back to when the ordinance was passed in $1,900, calculate what the first year's change was, calculate the second year's, and then round. I mean, I don't care where we round up. I would round everybody up as opposed to down to the nearest dollar.
I think that's fair.
Yeah.
Okay. Further question on the first elderly tax relief. Ms. Tarkington.
Yes, Mr. Bortney. Again, I didn't bring a copy of my ordinance, but does the ordinance have a provision such that the amount of the tax credit relief is indexed? What about the amount of the tax deferral? Is that indexed also, or is that not included as an indexed item?
We had no applicants last year on the tax deferral, and my mind is not fresh on that question.
Well, I think perhaps you can just go back and look at the ordinances. Can your colleague from the law department, just to make sure. And then, I had a question about the change in the maximum house assessment and what it was last year and how it had changed. And you very kindly had sent me the number, which it has declined by 10.6%, which is slightly less than the overall decline in the residential portfolio under this, the new reval. So I thought, in case anyone looked at this and thought it was down, it really isn't down as much as their overall values are down in the town. Thank you.
Further discussion on the assessors, well, let's stick with the tax relief and deferral program. Okay. Further questions or comments on the assessor's report? Mr. Raymer.
Mr. Gortney mentions at the top of page 2 that he made a presentation to the Riverside Association. I know that Mr. Gortney has made this presentation 8 or 10 times to other associations. The Riverside Association was the only one that I was able to attend. But on a positive note, I thought it should be mentioned that I thought it was a very clear and informative presentation. I thought it was very useful. I thought I learned quite a bit, and I thought I was supposed to be somebody who wasn't supposed to be learning things from attending that session, but I thought it was very good, and I think credit should be given where credit is due.
Thank you.
Mr. Finger.
I have a question, Ted, on your report, item 1, normal workload, the real estate. You indicate that the appraisers have reviewed 64 permits with 1,249 remaining to be inspected.
Yes.
Is that normal workload, or has the revaluation impacted the ability of the appraisers to stay up to normal pace in reviewing the applications or the permits?
Well, the appraisers are spending time actually inputting the results of the informal hearings. They're first reviewing them and then inputting them and making corrections to the database. So it's probably slowed down for where we might be in a normal year. But they should be able to pick up as the time proceeds.
So this doesn't raise any red flags?
No.
Okay, thank you.
Further questions? You will note under our agenda this evening, under old business, request for additional revaluation information falls under that section of our agenda. Is there a motion then to accept the assessor's report?
So moved.
Moved by Mr. Raymer, second by Ms. Tarkington. All those in favor signify by saying aye.
Aye.
Opposed, abstention, 10-0-0. Ms. Tarkington.
Yes, Mr. Chairman. I'd like to move that we move forward the old business item, request for additional revaluation information, and put that on the agenda at this point, please.
Moved by Ms. Tarkington, second by Mr. Pellegrino. Discussion? All those in favor signify by saying aye.
Aye.
Opposed? Abstention, 10-0-0. So item 11 now comes before us out of order pursuant to a vote by this body. Let me just, if I'll first take a stab at least what's in the assessor's report, and then I'll turn it over to the revaluation team. This was an item that came before us, I believe, last month. And I'll just read the assessor's report, at least at this point. It says land influence factors are shown on the public record cards, but not shown on the public computer monitor. When the public record cards are printed, the land influence factors appear. We have asked our software vendor if ProVal could be changed to also show the land influence factors on the public computer monitor. They stated it would be costly and could only be included in a future new release. We are discussing alternatives with the BET and plan to make a recommendation to the February BET meeting. So with that, let me turn it over to Ms. Tarkington, Mr. Finger, one of you, to discuss this matter and shed some more light on this issue.
Yes, as we said in our report, the revaluation team, Mr. Finger and me, met with the assessor and the assistant assessor to discuss land influence factors as was brought forth by the town assessor at the December 2010 meeting. Both team members have been contacted by the member of the public who had brought forth this issue, and we've had lengthy discussions with this person. After our meeting with Mr. Gortney and Mr. Shipman, we found that there was additional follow-up from the meeting, And as proposed at the BET's December 2010 meeting, the team expects to make its recommendation on a solution to the land influence factor issue at the BET's February 2011 meeting. I want to point out, because we need additional time and at least one, if not more than that, with the assessor and the assistant assessor. It may propose then that there be a first reading of the issue to provide the public time to comment, and that the BET vote on the team's recommendation may be held at the we may recommend that recommendation that it be held at the March 2011 meeting.
So the issue with this, we had a little bit of a discussion at our December meeting, and this is somewhat different from the issue that we had a year, 2 years ago regarding access via the internet. This would be information that, on one side of the argument, is it's simply an oversight by the, whether we want to say it's a technical oversight or it's a failure internally with the communication as between the systems or what have you. But this information is available. It's simply not available as to the extent that at least one resident would like to see it be available. Correct?
That is correct. There are books with this information available in the assessor's office. Currently, you can print out your property card, and that information is also available on the card.
So I guess my concern is whether or not we truly need to elongate the process even further for a first reading, getting it out there in the public, or we can wrap this up in February, because the concern is just one of timing. If we think we need that, that's fine. And we've talked about it last month to at least some degree relative to people listening out there. We're talking about it again tonight, although we don't have any particulars for the board. But do we think it's of such an issue as putting out information out on the internet that would cause, or there to be a reason for, say, a public hearing? If that's the response from the team and the recommendation, I don't think I'm going to stand in the way of that. I just want to make sure we move the process along. Mr. Finger?
I'm not sure that at this point we're able to, or Leslie and I are prepared to say definitively that there should be a public hearing. I think what we have learned is that it's not, there are more issues than just getting the information on a ProVal disk. If we want to have the information available in the public monitor, the way things are now, that may result in more information being available to the public than we might otherwise need to have available. It has a lot of information that the assessor's office uses on an ongoing basis. So there are a lot of factors, and I think probably when we make our recommendation to the BET in February, we'll have a discussion with the chair, and you can make a decision, or jointly we can make a decision whether a public hearing will be necessary. I'm not sure that a public hearing will be necessary, but at the same token, I don't think either one of us are prepared to say it won't be necessary in light of the conversation we had a year or two ago.
Okay.
There's no definitive answer to your question, but I think that's where we are right now.
Okay.
Just one more comment.
Mr. Simon?
Yeah, I think, though, that if I were going, because I think it's important that we distinguish between the ProVal disk and the public terminals. Because if I'm going in and I'm looking at a property on the public terminals, and I want to know why someone's assessed for less than I am, and I can't see the land influence factors on your property without printing out the form and not knowing that if I'm going to pay to print out the form that there's going to be anything on it, that's really withholding information from the public, which I think should be available. And so I think we should address whether it should be on the disk, whether or not it should be on the terminal. Because although we print out the field cards for the assessment, 3 years from now, we're going to have other land influence factors, and those aren't going to be readily available to the public.
Mr. Finger?
You're absolutely correct. And when we had the discussion on this issue at our last meeting in December, last BET meeting, I think we were focusing on whether the information should be available on the ProVal disk. And what we've determined, it's more than just an issue of should it be available on the ProVal disk. There is a question of whether or how we can get it, if we can get it available on the monitors that the public sees. Because I think both Leslie and I agree that the public should be able to see it. But again, it's not a clear, simple issue. There are software issues, there are ProVal versus Munis. I mean, there are many issues that came to our attention when we met with the assessor and the assistant assessor to discuss this matter this month. So that's why we need a little bit more time. And as we initially indicated, we will be making a recommendation in February.
Okay. Mr. Simon.
Yeah, I understand that, but I think there's a difference between saying, all right, intellectually, we think it's important that we have the information available on the terminal, but we're not going to be able to do it until the next release of ProVal, which may be in X months or X years. Or as opposed to saying, I don't think we should intellectually allow the data to be shown on the terminal. And I wouldn't go off and spend hundreds of thousands of dollars to upgrade ProVal.
We're not suggesting that we do that.
Right, I'm just saying that's how I feel personally.
Okay, I think all of this also is in the context of, obviously, we're going through a reval now, and if people want this information in order to go to the Board of Assessment and Appeals, and we're having a cutoff of March 21st, I mean, that's sort of the balancing act, at least right now, and the timing issue that we have to at least consider when deciding whether or not we're going to take action in February or then hold off until March. So we'll leave it at that. And maybe it's that we would do schedule a public hearing in February at the time that it's rolled out, and so we sort of truncate the process. I know the one resident who is interested in this information not only is here tonight, but has had several conversations with us and at some point would like to address this body. Okay. Mr. Gortney, do you have anything to add to this other than it's coming back to us in February?
No, we'll be meeting with the committee and discussing it in full.
Okay. Anything else on this topic? Any questions now from board members so that they have your thoughts in terms of going into the recommendation? Okay. Well, then, hopefully we get either a definitive response in February, or we set up a process to where it's going to be February, March with the public hearing. But I think at the very least, my inclination is to hold a public hearing at least in one of those 2 months to make sure that we don't have a repeat of what happened to the information issue that came before us a year or so ago. Okay. Item 5 now comes before us, Comptroller's report.
Good evening. On the front page, the 10-11 capital project financing, we went to market last week and we did well again. Prior to going to market, the AAA ratings from the 3 credit rating agencies were reaffirmed, and we retired $45 million of bonds by bonding $30 million, and we had $18 million of new money with a note issue of $33 million. In the second paragraph, I refer to the rate of 2.29, which is a blended effective rate over 1.84 a year ago. And let me explain what the blended effective rate means. There was $30 million of permanent finance and general obligation bonds. Of that, $25.48 million was general fund. We got that at a rate of 1.45, and $1,520,000 was sewer improvement, and $3 million was Nathaniel Witherall at a rate of 3.867. So the general fund portion, the bulk of the financing was retired in 5 years, and the other 4.52 was retired over 20. which came up with an effective rate of 2.29. However, when you apply the general fund debt service in the budget, we're using the 1.45 rate. And the bids for the bands were at 38 basis points. This is rounded. It was slightly less, 37.9. We had a rate of 28 basis points last year and 38 basis points 2 years ago. So we're still enjoying very low interest rates at this point. Good news on the bottom of the page, we finally broke $300 million in the retirement fund. We're at $304,437,000. I'll answer any other questions you might have in the Comptroller's report at this point.
Questions for the comptroller? Ms. Tarkington.
I'd just like to thank Peter and the others that were involved with both our success with the 3 rating agencies and the success in terms of the bands and the bond issuance. So, good work.
Thank you, and I'd just like to add that the credit rating review was Mr. Tessie, the first selectman, Peter Tessie, assisted on the rating review, and also Roland Geiger. And thank you again.
Further questions or comments? All those in favor signify by, is there a motion to approve the comptroller's report?
Yes.
Moved by Mr. Pellegrino, second by Mr. Mason. All those in favor signify by saying aye.
Aye.
Opposed? Abstention, 10-0-0. Is there a motion to accept the treasurer's report?
So moved.
Moved by Mr. Simon,
Second.
second by Mr. Pellegrino. Discussion? All those in favor signify by saying aye.
Aye.
Opposed? Abstention, 10-0-0. Items 7, 8, and 9, dealing with the BET Standing Committee reports, the BET Liaison reports, and the Special Project Team reports, are now before you either in written form or unless we have a presentation here today. Questions regarding any of the reports? We went through the revaluation team report and for most of what it was doing this past month. You have a report from the audit and investment committees as well. Discussion.
I just have one comment.
Mr. Simon.
So I think we're very close to issuing the RFP for the HR study. We have agreed on the scope of service, and we're going to, I think we're going to be ready to issue it by the end of this week. So do you think we should circulate it to the BET to see if people want to read it, or just continue the delegation that we've made prior to the small committee?
Well, the last month we voted to delegate, but I think if you circulate and if people have comments, they can get them back in. I think it's always better to have, if there's some glaring issue, then the small team can resolve that one issue. But to circulate, I think, would be helpful.
All right, I'll send it to Peter tomorrow, and then we can get comments on the scope of service as opposed to any of the other items within the technical part of the RFP.
Just give a clear deadline of whenever you want those back, and then people who have comments to make sure you get them in. You either get them in or you don't get them in.
Is Friday okay?
It's fine. If that's when you need it by, that's when it'll
I
be.
think we want to go out and issue this next week.
Sure. Okay.
Okay. Further discussion on any standing committee, liaison, or special project team? Okay. Item 10 now comes before us, Chairman's report. Certainly interesting times as we gear up for the submission of the budget. Since last year, since the passage of last year's budget, we've had certainly sense of the meeting resolution, at least one passed. Several others, I think, were proposed. You should have all received emails or correspondence. I certainly have received one called the Year Jubilee 1954 and reprinted in 1979. I've seen a Greenwich Time report from 1991 entitled Town and Its Budget Have Changed Greatly Over 10 Years by our former first selectman. It's interesting reading relative to today. I'm not sure if it had 1991 on it or the author's name. I would have guessed when it was, and I was surprised that it wasn't speaking of our issues facing us today. So my only comments for this board is to get your sleep now, rest, because it looks to be like an exciting February. We have a lot of work to do in reviewing the budget submissions. We look forward to the first selectman's presentation and the Board of Ed's presentation. And I'm going to just briefly go over those dates. So the first one out of the box is the CIP committee. Technically, that's not our public hearing, but it is the first one concerning the budget when people are starting to focus on it. It is January 31st, 2011. It's at 7:30 here in the Town Hall meeting room. The next public hearing is February 7th at 7 p.m. here in the Town Hall meeting room. Technically that's handled by our Budget Committee. And then, after the Budget Committee reviews the budget and makes its recommendation, the BET's public hearing is on March 29th at 7 p.m., again here in the Town Hall meeting room. So those are the three opportunities that the citizens have an opportunity to speak and talk about whether it's capital or operating, and where the citizens can tell us whether or not they have an opinion about where and how their money gets spent. I would also note and tell everyone I've heard comments or criticism that especially with meetings at night and during the winter time that it might be difficult to get out to these public hearings. Let me assure the public that any email that I receive, and then if finance receives it, they forward it to me, then gets forwarded to the entire BET. So the opinion that, well, I can't get out or I don't want to speak out on a particular or speak for a particular item because I don't either have the time or can't get out those particular nights, I can assure you that a simple email does the trick and does it effectively. So anything that comes to me or to Mr. Mason for the Budget Committee will get distributed so that the opinions are heard. We have rearranged the schedule, which I guess just then flows in from my remarks right into our budget calendar. There were some changes made, some for members, BET members, to accommodate schedules there, some other official schedule, and to try to the best possible, stay away from public school vacation, which is during a week in February. This has become somewhat problematic. I appreciate everyone's attentiveness to these changes. I think we have a calendar here that fits most people's schedule. I know Mr. Raymer has still some conflicts. I apologize for whatever role I've played in this. We just try to make sure. One of the issues that I take very seriously is to take off the table any procedural snafus. Certainly, we can debate issues. We can debate the issues on their merits. But when citizens, especially, make comments that they didn't feel like the process was fair or that they had an opportunity to speak or come to meetings, that's what bogs down the process. So in doing these changes, as much as it has impacted everyone having to rethink and relook at their schedule, I think it attempts to accommodate some criticism regarding the public school vacation break, and I suspect that maybe next year we can either revisit that issue before we set the schedule or somehow not make the accommodation and just say, listen, that's just the way it is. But for right now, the schedule is before you with 9 changes, and I would ask for this new calendar to be approved tonight. And so is there a motion?
So moved.
Second.
Moved by Mr. Simon, second by Mr. Pellegrino.
This is the one that says version 4.
All those in favor signify by saying aye. Aye. Opposed? Abstention. Okay, I appreciate that. Mr. Raymer.
Just one thing, mostly for the people on Channel 79. The chairman mentioned that on the 7th of February at 7 p.m. is the public hearing on the budget. Perhaps the chairman would like to mention also that at 6 o'clock that night actually is when the first selectman presents his budget, and at 6:30 that night is when the Board of Education presents their budget, and it's the public hearing that starts at 7. But if somebody wants to hear the presentation by the first selectman of the Board of Education, they'll want to come at 6 p.m., not 7 p.m.
Thank you, and if I said that, I would just be repeating what you said, so thank you. I think it's a great addition. We set that up several years ago, so in fact, those who are coming out for a public hearing get the opportunity to also hear what the first selectman has to say and what the Board of Ed has to say. I think it's one of our most successful changes in our calendars over the past several years. If I might be indulged yet again on the calendar, however, I received a call today. This has been an issue actually that started earlier, but solidified today. And it's a request, and I'm not going to ask for the change right now unless there's a movement to do this. I think we have to check our schedules and do things like that. The tax collector has suggested that because the RTM votes on the budget on May 9th, that any change to move up the date of the BET meeting, which sets the mill rate, to give even more time to ensure that the tax notices are printed in a timely fashion and sent out in a timely fashion would be beneficial. And certainly not one who wants to encourage a repeat of what has taken place in the past regarding the tax notices. The suggestion was to move our meeting from our normal Monday, the 16th. We could not do it on Tuesday because that's when the Budget Committee would meet, and I don't want to move the Budget Committee up to when the RTM meets because that creates problems, is to, if available, if a room is available, and if we can accommodate this, to move that meeting on the 16th to the 11th. I'm only going to put it out there now because I don't think it changes the whole calendar. In fact, we can get started on this. One of the concerns is that this calendar is now not on the website because we're changing it so much. So we can vote on that next month, but I want everyone to know that that's what's coming down is a request for it to be on the 11th. It could even be on the 12th, but then once again it becomes a de minimis change at some point. So
The 11th is the night of the Democratic Town Committee meeting.
at 8?
It meets at 8.
Okay, good to know. So we'll talk about that to see if we can make that accommodation. Okay. We're still under new business, item 12, the approval of the OPEB actuarial report. Is there anybody who's going to present that? Peter Menarski, our comptroller.
I'll move it.
You going to move it?
Well, Mr. Simon, why don't you move the item? We'll get it on properly before us.
I move the approval of the OPEB actuarial report for the period starting July 1st, 2010.
Second by Mr. Pellegrino. Mr. Menarski.
The actuary report that you're going to approve tonight is for the other post-employment benefits fund done by Hooker and Holcomb as opposed to the retirement fund, which is done by EFI Incorporated. Bill Wollicott, the consultant from Hooker and Holcomb, gave a presentation to the Budget Committee last week on Wednesday, and it was a question and answer session after the report was presented. This product is this report is the product of a number of months of work that a ad hoc committee led by Mr. Simon and Allison Graham from the HR committee, Roland Geiger and myself worked with the consultant trying to get the most accurate document out there. We're proud of it because it's come a long way in the last 3 years from what we had when we hired Hooker and Holcomb. So before you tonight is the OPEB report, actuarial report for your acceptance.
Further discussion.
I'd just like to make two or three
Mr.
comments.
Simon.
I think what's important about the actuarial report is that the liability, as we've refined this report over the last 4 years, I think the liability has declined from 101 million to 51 million as we've gotten more accurate about it. Our assets at the end of last year were 16.3 million, and so our unfunded liability was $35 million. Our OPEB fund is $2 million, or $21 million. And I think as we keep working on this report and working on some of the changes within healthcare, I think we can get the liability down into the $40 million range, and our unfunded liability will be in the $25 million range, which I think is pretty good for us. And our annual required contribution this year is $3.661 million, and it's projected to go up to $3.722 million for next year. And I think, as a town, we've done very well in terms of understanding our obligation and meeting our obligation.
Further discussion. All those in favor signify by saying aye.
Aye.
Opposed, abstention, 10-0-0. Thank you. Mr. Pellegrino?
Mr. Chairman, I'd like to make the motion that we take up an item that is not currently on the agenda. The item I would like to take up is a request by the Retirement Board to enter into a contract with an investment management company, that being Audex Management Company, LLC, for the purpose of making an investment in a mezzanine fund being sponsored by the company, that fund being Audex Mezzanine Fund 3.
I second that.
Okay, it's been moved by Mr. Pellegrino, second by Mr. Simon, to add the item of approval of a contract with Audex onto our agenda. This would require a 2/3 vote. I will note that, as you all know, and as I've stated in the past, I don't really like doing this unless there are extenuating circumstances. The extenuating circumstances surrounding this item is that this did not come to my attention until Friday late. By the time my email got to the towns to change the agenda, it was the town staff had left for the day, and so it didn't get posted at that point, and therefore posting it this morning would have been of no consequence. I also don't think that even if it was posted, we would have had many people here tonight to talk about this contract. So with that, let's take this to a vote, and this is just to put it on the agenda, the Audex contract. All those in favor signify by saying aye.
Aye.
Opposed? Abstention. 9-1-0. That motion passes. Mr. Pellegrino, on the, you want to just move the item?
I would like to move the item.
Okay. Is there a second? Second by Mr. Finger. Discussion.
If I may make a comment first, the reason for the item coming at the last moment is really because there has been lengthy and detailed negotiations between the town attorney, and the legal representatives of the fund, and they were not able to reach an understanding until this past Thursday. So that's the reason for it coming to us late. It's no reason other than that. If I may make a comment on what this is about. The Retirement Board wishes to make a $5 million investment in Audex Mezzanine Fund 3. The form of the investment will be as a limited partnership interest. The commitment of $5 million will be drawn down as needed over a 5-year investment horizon. There will be an annual management fee of 1.5%, and on the committed capital, and then once it's invested, that drops to 1%. We will receive a credit back, however, as funds are distributed from this investment. The investors will have an 8% preferred return before Audex earns a performance fee. The structure of this investment is as subordinated debt. It has various equity kickers so that the targeted returns on a gross basis are 15 to 20%. We believe that the net basis to us may be in the range of 11 to 16%. It is also an investment that will throw off current income to the investment fund. The investment strategy is to make investments in the middle market. That's the dollar size of the companies we're talking about. And it will be in the form of subordinated debt with various equity components to enhance the return. This is the third fund for Audex. Their first two funds have proven to be, I'd say, frankly, highly successful. The retirement board initially wished to do a $10 million investment here, but we have literally been cut back to $5 million because it is oversubscribed. And the deadline for making the commitment is this Friday, the 28th of January. I should add one more comment. I apologize. We did hold a investment advisory committee meeting this evening. It would not be in proper form because we were not able to give a 24-hour notice, but we were able to discuss it amongst the three members of the committee that were in attendance. Mr. Norton was not able to be there because he is scheduled to be out of town today. And the three of us voted in favor of it 3-0. Sorry, thank you.
Ms. Barton from the Law Committee.
The Law Committee did not take a vote on this item. It came to us literally at the last minute. We had a meeting scheduled earlier this afternoon to cover another matter, and we discussed this matter at our meeting but did not take a vote. Speaking solely for myself, I have a concern about the fact that the fund or the investment advisor to the fund is not registered under the Investment Advisors Act and is therefore not subject to the requirement that there be a separate custodian of the funds. I have not had enough opportunity between 5 o'clock and now to understand fully the implications of that, but it gives me great concern, and as a result, I intend to vote against this investment.
Further discussion, Mr. Campbell.
Yeah, just for the record, we did, in fact, the Law Committee agenda did, in fact, include this item because we got word on Thursday that this would be on our BET agenda this evening. But as Ms. Barton said, we only saw a memo from the Law Department when we arrived at the meeting, and I think she's described the leading issue that led us not to actually vote on the matter. I know that Mr. McLaughlin is here from the Law Department, and if we have further questions on that issue, we may want to speak with him.
Mr. Simon.
I think we could ask Mr. McLaughlin to clarify those 2 points, but I'd also like to just comment on the investment opportunity here. Originally, we wanted to invest the $10 million. Then we were told we were unable to, I guess, reach an agreement on the business terms of it, in terms of the indemnification. Then we seem to have made significant progress. And I think from the retirement board's point of view and from the town's point of view, this is a terrific type of investment. I'm sure they're only letting us in because they want to have us as a client and add to their prestige, as otherwise they wouldn't bother with a $5 million investment. And I think for us, it's a good opportunity to find these kinds of investments where we can get a chance to get significantly higher returns at an acceptable level of risk. And I would recommend that we approve this investment tonight. And we could discuss later whether we want to have it subject to further approvals, but I don't know that I think it would be proper just to let the Law Committee have sole voting authority on this one investment, because we won't be meeting after that, and we have to make the investment by Friday.
And Mr. Chairman, I'm sorry, just to clarify, the Law Committee did not vote against it. The Law Committee did not take a vote on it because that issue arose, and we really felt we didn't get clarification during the period of time when we had the scheduled meeting, and now here we are this evening at our full meeting. So I'm afraid that's what you've got from the Law Committee.
Further discussion. So as I take it, the sole issue on this, other than the fact that it's coming before us in this fashion. Took a while to negotiate on the terms, getting them to agree to the indemnification agreement or language, is the fact that you have an unregistered fund advisor.
An investment advisor that is not registered under the Investment Advisors Act of 1940.
But my understanding is that they have agreed to seek registration. Is that, Gene, do you want to
There is
comment on that?
there is a conflict on whether that's true. Jean can explain that.
Good evening.
Hey, Jean.
The holdup was the requirement by this ODAX fund to have the town indemnify the fund in case there was any misrepresentation or activities by the town that caused loss to the fund. And it wasn't until early Friday morning that ODAX attorneys finally agreed to language that waived that requirement. Got an email that was dated, I think it was Friday morning at 2:35 a.m. Their attorneys gave language that was satisfactory. We have made a good deal of headway in what's called a side letter agreement with ODAX that clarifies a lot of the provisions of the agreement. For example, we have found out that ODAX has errors and omissions and fiduciary liability coverage of $50 million. Before we got involved in this, they were willing to put in a side letter that they had $2 million worth of insurance. The standard here is a gross negligence standard and willful malfeasance or gross negligence, which is similar to private placement funds of this kind in terms of the standard that the trustees or the managers of the fund have. We did obtain during the course of this a copy of the agreement that the state of Connecticut Treasurer's Office had with ODAX, and including the protection provisions that were in the state agreement. We were able to negotiate with their attorneys to get those kind of protections and clarifications in this agreement. One of the things that we picked up, however, was in this particular fund as opposed to the energy fund, the investment advisor is not registered as an investment advisor, and at least the preliminary filings in the private placement memorandum was they had no intention of doing that. However, we made an inquiry with regard to both that and the custodian of the securities, and we're advised by the attorney that they are not doing that now, but they intend to do it. I bring this to your attention because this is a difference that we picked up between the types of investments that are actually even on your agenda today. The State Street Global Advisors, for example, we have a direct agreement with the investment advisor. We have indemnification, we have insurance, and they are a registered investment advisor, and there's a separate custodian for those securities. The energy fund, for example, did verify that they have a separate custodian and that their investment advisor is a registered investment advisor, and that they have a separate custodian for their funds. These funds are the types of funds that are established by a private placement memorandum by a company that will attract investors, and it's not quite take it or leave it, but it's close to that. And this is the best agreement that we were able to reach in terms of this board. As a prudent investor, you have to balance the risk taken and the return versus the risk that's being taken. And we can recommend this because of our review of the State of Connecticut agreement and the protections that the State of Connecticut vetted and thought were adequate, and the other protections that we're able to negotiate in this. However, I just wanted to bring to the attention of the board, the law committee, and the investment committee that there are differences between these agreements. The risks are different, but the risks may also be different. The returns may be also different based on the type of the fund.
I'd like to just make a few comments to my colleagues of why I'm comfortable with this investment. First one is, this is not a blind pool. This is not the retirement fund putting up the $5 million and then being informed later what the investments are that the investment manager is making. The way this works is you make a commitment. You only fund the commitment when the investment manager has a specific deal that they're going to undertake. As soon as your money is called, that money is placed in the deal that's being invested upon. XYZ company, it could be for purposes of growth, acquisition, or project financing, whatever it is. Unlike an investment in an investment manager, where someone is managing your money, there is no public market for these securities. There are no securities. In fact, what it is an investment in a company. At the end of the day, that investment will either work or it will not work. So I am not concerned, personally, I am not concerned that there is not a SEC registered investment advisor here per se, and I'm not concerned about the custodian issue because there really is no holding of funds other than a nanosecond between the time we fund and the time it goes into the transaction. Other than that, I would second what Mr. Simon has said. When you look at mezzanine deals and you look at the potential return and you look at the track record that these people have, they're probably as good as we're going to get an exposure to. The fact that the state of Connecticut is in there for significantly larger dollars, the fact that there's other larger investors in there for significantly larger dollars, the fact that we were cut back to $5 million, all those factors weigh in my decision-making in terms of support for this investment.
Further discussion, Ms. Barton.
I would just emphasize that this is an investment in a security. It may be unregistered, which is fine, but the fact that the investment advisor is not registered and there is no separate custodian for the funds is very concerning to me.
Further discussion. All those in favor of the contract, I guess it's a contract approval would be the how the minutes should be reflected. Signify by saying aye.
Aye.
Opposed? 8-0. That item passes. Okay, thank you. Item 13 now comes before us, approval of the regular meeting minutes for December 20th, 2010.
So moved.
Moved by Mr. Pellegrino,
Second.
second by Mr. Simon.
My role tonight to be
Discussion? All those in favor signify by saying aye.
Aye.
Opposed? Abstention 10-0-0. One abstention. 9-0-1. Any other business to come before us? Meeting is adjourned.